information or opinions.
Sanders, a name you can trust. With over 20 years of real estate experience and selling over 150 homes a year, Laura Sanders is the #1 RE/MAX agent in the state of Florida for 2021. Join us each week as we discuss how to make money through buying and flipping homes to renting versus selling and everything in between. To join the conversation, call in live. 888-994-4995, Studio A.
Hi everyone and welcome to Making Money with Laura Sanders, and I am Laura Sanders. Thank you for being here with us tonight. Every week we do something a little different, trying to figure out ways on how to make you make some money or save some money. So I had some situations that happened this past week that really made me realize that this is probably one of the most important shows that we could have, and that's on wills, probate, and trusts. So I had a friend just recently lose their mom, and they didn't have anything set up specifically on to keep them in the home that they've been living in for the past 40-something years. So people don't think about that there's going to be an accident, that they're going to die. They don't think about any of these things before this happens. So that's what brings our guest today, Gary Handin, from his real estate company, from his firm for wills, trusts, and probate. So welcome, Gary.
Thank you very much, Laura. Glad to be here.
So everybody talks about probate, and even I actually first time had to use a piece of paper. Normally I can just go off the cusp. But probate, how do we avoid probate?
Well, first of all, probate is something that has been made to sound very scary. What it is it's a court proceeding. When someone passes away, if they have assets that are in their own name, they're going to want them to go to their loved ones or whoever it is that they care to have it. So if you have a will, then in the will you can say who you want to get your property. That does require probate, except I'm going to show you some ways to get around it. If you don't have a will, then there's still probate, and only the state statutes tell you who's going to get your property. So it's a great advantage to have a will, so you get to say what happens.
Okay, so you're gonna tell us how to avoid probate,
right?
But it wouldn't be all of the time, or could it be all of the time to avoid probate?
It could be all the time, depending on the kind of assets that you have. Most typically, people have a home, and chances are, if it's a husband and wife, they own it as what we call tenants by the entireties, which means if one dies, the other one gets it, and it's a special type of joint tenancy just for married couples.
Okay.
Now,
so let's say, for instance, though, this married couple has 3 children, and they were to pass away together in a car accident. What then would happen?
Okay.
How would we avoid probate?
Well, we can avoid probate by having planned in advance for, I'm assuming they want to have their kids have their property. So
Okay.
you start there and they won't have it equally. We can use something called a ladybird deed. And this is a deed whereby the people, the husband and wife, would have prepared in advance. They prepare a deed. They go to a lawyer. You can't do this yourself.
Okay.
You go to a lawyer. The lawyer prepares it so that you deed it from yourself to yourself for life, for your life. And then when the last of you passes away, then it goes directly to your children or whoever it is that you say that you want to get it. Okay? So that's one way of avoiding probate.
And I love the ladybird deed because a lot of times people, let's just say you have a child that's could be a drug addict, but you want to still leave them your assets. You don't want to put their name on your deed because then they could be in control of whatever happened. Like if you say, oh, you know what, I'm going to sell this house and downsize to a condo, with a ladybird deed, correct me if I'm wrong, that with the ladybird deed, then that person has no say over what they do and they can just put them on the new property and never need them to sign anything, where if they had put them on the deed, they would need to sign.
That's correct. And there's an additional part to that, because if they put them on the deed, then if they want to go sell it or refinance it, they're going to need that person, we call the remainder man, to sign off on it also.
But
so
not
with a ladybird deed, you can retain control of the property. Nobody gets anything until you pass away. And if it's a husband and wife, for argument's sake, nobody gets anything till the second of them passes away.
Okay. You know, this is such a I see real estate every single day. That's what I do. If I've seen 5 ladybird deeds in 20 something years, I think that's such an unutilized.
Well, it's interesting you say that, because I have people, no fewer than 3 or 4 a week come into my office where it's the appropriate thing to do. Now, sometimes they're referred to me by other attorneys who don't do this type of work. A lot of times they're referred to me by title companies who can't do the legal work. They do the title work, but they can't do the legal work. So, but it's becoming much more common. And of course, when I'm doing wills or possibly a trust for someone, this is one of the tools that we use to try and eliminate the need for probate. Right. The only time you're going to need probate is if you have something in your own name individually, and you, as I said, you either have a will or you don't have a will, and you want to leave it to somebody special, in particular. So there are ways around it. A joint account, for argument's sake, with savings accounts. Or there are pay-on-death accounts where you can name a beneficiary. Your IRAs, you name a beneficiary. Your 401k can name a beneficiary. And so it affects not only real estate, but your personal property. And all of those, from joint to the joint deed, to the ladybird or enhanced life estate deed, to pay on death and transfer on death for stock accounts, are all ways of avoiding probate. All of those things pass outside of probate, and you need not go near the courthouse, nor do you have to, do your descendants have to go to the courthouse and get any court order to distribute the assets.
So what I do need to tell you guys is that I have used Gary multiple times for clients that needed probate. One of the things that I have to say, because recently I had somebody that didn't use him because they were kind of outside the realm, they weren't really my client, and it took forever for probate to be completed on the numerous occasions, and I don't know how you do it, so tell me how you do this. You get it done in like 3-4 weeks. Is it like because you know people, because you've been around? Like, what are you doing different? Well, I guess you don't want to give your secret sauce, but it's amazing how fast you get it done. And I tell people, but they don't understand. Like, I had a lady that had called, said, you know, I should have used you originally to sell my other house, but now my father passed away. I need to do probate. This realtor, this lawyer, she told me it's going to take 6 to 9 months. If you remember the deal, it was like maybe a year and a half ago. Right. And you did it in 3 weeks. And this is during right after that COVID, and things are really backed up, and you were done in, I think it was 20 days. You told her 3 to 4 weeks because you like to over-deliver, and under-promise.
Right.
And she was like, I can't believe this lady told me 6 to 9 months. You got it done in 20 days.
There are times that probates take time, and they cost substantially more than going through these other procedures to avoid probate. Mm-hmm. You can, if there are assets that are more than $75,000, mm-hmm. and then you have to do a formal probate, which does take more time and involves much more work.
But wouldn't that be a house, though?
Well, that's it. So in this state, we have a homestead, and the homestead law and the way the laws are set up is if the only thing that's in the estate is the homestead, then that does not get included in the $75,000.
Okay,
so
that's great.
So if you have a house that's worth $500,000 and you have a bank account that has maybe $50,000 in it, you can still do a summary administration. And if you're on the ball, I'll pat myself on the back here. Okay. If you're on the ball, you can get it done in weeks, not months.
Listen, you're not going to break your arm because I'll pat you for you. But so then tell me, why are these attorneys telling people it's going to take 6 to 9 months?
I can't answer that. And it's not like I'm sitting around I have nothing to do. So it's not like I have one file at a time.
I mean, you've been doing this for how long?
Many years.
Many years. So if people were looking to get, their affairs in order for something that could happen 40 years down the line, because this isn't for something that's going to happen now. It could happen tomorrow. It could happen next week. It could
We
happen
don't
in
know.
40 years. We don't know. Just like we get in a car accident, it's an accident. That's why car insurance is so expensive, because you don't know when you're going to get in an accident, right? So what would be a good number for people to reach out to you, and a good, maybe a website or an email, something?
Well, the website is www.handinlaw, that's HANDINLAW.com. My telephone number, I'm in Coral Springs, 954-796-9600.
Okay, that's an easy
So-
enough number to remember. And you can always reach out to me. You can call me at 954-650-0827. You can go onto my website and send me a request, and I'll get back to you right away at laurasell, that's without the S, .com. And you can also call me or email me at lauraess@bellsouth.net. Yes, it's a very old email. So, so going on to other things here, I mean, any other recommendations that you would make to somebody up front without giving all your secret sauce?
I'm glad to share the information, really.
Okay.
When I have clients in, I try and keep them out of probate. Look, probate takes time and costs money. The legal fees on probate are substantial. According to the Florida statutes, the recommended fee is 3% of the gross estate. So if you're talking about $1 million estate, you're talking about a $30,000 fee. So if you can avoid,
That's a lot of money.
it is. If you can avoid paying that, even though I'm the lawyer, I don't like paying lawyers' fees when I need the legal assistance. So I understand that as a consumer as well. But there are ways of avoiding it. We've hit upon some of them, and that are the real simple ones that almost anybody can do by naming the right people in terms of joint tenancies and that type of thing. Otherwise, a tool that's very popular today is a living trust.
Okay.
Not a living will, a living trust.
Okay.
In a living trust, you take all of your assets during your lifetime, you put them into your name as trustee of your trust, and it can be a single person or it can be a married couple. You put them into the trust. You have as much control over them once they're in the trust as you did before you put them in the trust. And upon your death, upon the death of the first person, the second one just takes over. There are no legal consequences to it.
Okay.
Upon the second of them passing away, which presumably would be when their children get whatever they have, you name a successor trustee, someone who you trust, whether it's one of the kids or more than one of the kids, and then whoever the successor trustee is just distributes the assets that are in the trust. Again, no probate, no court costs, no attorney's fees, maybe a couple of hours worth of guidance from an attorney just so that they know what they're doing, and you can have a distribution of that estate within weeks instead of months. If it's bank accounts, you can have it literally within days.
So is there a way, so I would think, as someone with children, that it would be kind of concerning that if, let's say, you don't have parents, right? You don't have siblings, and your parents, and you don't have anybody to make that successor, and the children are still young, who would you then appoint, and how would that work?
That is problematic. You have to have somebody who's older, who you trust their judgment in terms of handling money. In most cases, by the way, I didn't mention it before, but when people are leaving children their assets through a living trust, I suggest that they leave it in sections, meaning
Right.
the following. If you have
18.
kids, leave half of it to them at 21, half at 25, 30, you pick the age, doesn't
Right.
matter. You have to know your own kids and how mature they are.
Right.
But you can, that way, I figure if they blow the money the first time, at least they haven't gone through all of it, they've got a second bite at the apple.
Right. But even
But in
18 is kind of, so are there companies out there? I'm asking, are
Well-
there companies out there that are trustworthy, that are bonded and insured, that maybe you can use as your distributor?
All the major banks have trust departments. The only reason I would stay away from them is because obviously they charge fees. That's what they're in business to do, and the fees can be substantial because they too are a percentage of the money that they're managing. It also is a very impersonal thing. But
Right.
there are very few people who have nobody who they can name as a successor trustee. But you try and name somebody, obviously, who's younger than you are or the same age. Siblings usually.
But they couldn't empty your account.
No, they still have to use it for the benefit of the children or whoever you say you want to be used for. They get a fee, but that's it. Now, usually when I set up a living trust for family members, the successor trustee does not get paid a fee.
Okay.
Okay, so they do it for love and kisses.
But could they? But could they take the money and start spending it themselves?
No.
How is
So,
that?
look,
How is
there's-
that? I mean, listen, because these are like the questions. I think that this is like a really complicated subject. Next to taxes. Taxes is way worse. It's like Chinese.
For me too.
Yeah.
But of course, anybody can write a check. The question is, are they within the law in doing so, and can they get caught, et cetera? You know, we read about scams all the time.
Right.
But that's why you have to name somebody as a successor trustee, meaning somebody who you trust. Now, if you have, if someone were to do the wrong thing, if the successor trustee were to start dipping into the pot for themselves, then presumably the kids would have somebody, either a guardian or a step-parent or a grandparent, who would be able to step in on their behalf and bring a legal action against the successor trustee for misappropriating the funds.
But if the successor trustee is taking care of the children, then it would be hard to really ever.
Well, you're leaving somebody who you trust to dole out the
Right.
money, and that's different from a guardian.
Well,
You know,
I've talked to friends and they're like, who would I leave my kids to? I don't have anybody to leave my kids to. So in that particular, I mean, that's a scary subject, like to not know who would you leave your children to.
We're slightly off the topic, but in
Yeah.
the same ballpark.
Well, there's money involved, there's children involved, typically.
The guardianship is separate from the trusteeship. Okay, so the trustee is in charge of the money that's in the trust. The guardianship is the person who is in charge of the child. We're talking about minors here, obviously. So and that I'm losing the train of thought.
Yeah.
But that person, by the way, is not necessarily the person you name in your will. A lot of times when you're doing your will, you name who the guardian is for the kids, and that's what I think you're
Right.
really talking about. Who's going to take the kids and physically have them?
Right, and are they going to manage the trust? So, and there's a lot going on here, I know, so we're going to actually get ready to take a break, and we're going to come back and we'll regroup to get back, because I know it's a very complicated subject. So why don't we go ahead and go to commercial, and we'll see our sponsors. We have our Title Brothers, and we have Max Fish, who is our mortgage. So just stay tuned for our commercial, and we'll be right back.
Title Brothers LLC, our mission is to give you the best closing experience anywhere in the country. Founded in 2020 by Adam Lohman and Josh Wiseman, here at Title Brothers, we're your one-stop shop for residential real estate, title insurance, title and escrow services, real estate closing, and due diligence services. While primarily located in South Florida, we also host dozens of closings throughout the state and even electronically as requested. To contact the Title Brothers, call us at 954-995-4988 or visit our website and get a quick quote today.
Whether you're buying, selling, refinancing, or building your dream home, you have a lot riding on your loan specialist. Max Fish, a top 1% mortgage loan officer in the nation, will give you a same-day qualifying quote. Max Fish is committed to providing his customers with mortgage services that exceed their expectations. Ensuring that you make the right choice for you and your family is his ultimate goal. Contact Max Fish today at 954-729-6933 or max.fisch@nwmcorp.net.
You have been watching Making Money with Laura. For more information, contact Laura Sanders at 954-650-0827 or visit her website at lauracell.com. And now back to the show.
Hi, and welcome back to Making Money with Laura. We're talking about wills, probate, and trusts. This is a very complicated subject, so let's regroup and go back because it is so confusing. Durable power of attorneys, power of attorney. So I know that recently we just had a situation where I had a guy that his mother had Alzheimer's, and he had this durable power of attorney, but he had to send us the original from where he was at. So let's talk about that.
Well, the difference between everybody knows, I think, what a power of attorney is. If I say to you, Laura, do me a favor, I have this real estate deal in New York, and I can't go. I need you to sign the papers for me. Here's my power of attorney. Go to New York and sign them. That's what a regular power of attorney will do. But the power of attorney is only as good as the person who gives it. So if we take that same set of circumstances and I give you my power of attorney and you get on the plane and you're over North Carolina and I have a stroke and I'm now unconscious, with a regular power of attorney you cannot use it because you're only as good as I am. Okay?
I see what you're saying.
Okay.
You're not, okay.
By the way, just as a side note, a power of attorney is only good while the person is alive.
Yes.
Then the wills and trusts or whatever else take over.
It dies with the person, right.
Because I have lots of people ask me, well, after their parent died, yeah, but I have a power of attorney. Yes, but it's only as good. It's only good
It dies
while
with
they're
them.
alive. Anyway, so with a durable power of attorney, even if same set of circumstances, and I have that stroke, you can still act on my behalf. That's the durability part of the power of attorney.
So you're incapacitated,
Right.
and I can still make decisions for you.
Correct. Now, the durable power of attorney that we use is two-pronged. One has to do with financial matters, and one is a healthcare surrogate. Because with HIPAA laws, unless you have one, you may not be able to even get to see your loved one's health records. The hospitals are very particular on that. So I consider that durable power of attorney almost as important as having a will. Because if you do not have a durable power of attorney, and if in your old age you're diagnosed with Alzheimer's or dementia, or you're in an accident and you're incapacitated, and you don't have that durable power of attorney, you have no one to act for you, your family is going to have to go to court and have you declared judicially incompetent and have them appointed as your guardian.
Which then takes a long time for that to go down.
Takes months, and it can cost $10,000 to have a guardian appointed. And it's also invasive because the patient has to be examined by doctors that are not familiar with them. It's not a pleasant thing. So for a relatively small amount of money, you're better off getting a durable power of attorney, and I recommend that all of my clients do it when they're having their wills done.
Oh my God. So can you believe that we actually have no more time? We have spoken and we still really could cover a lot more. I mean, there's so much, but I think that I'm going to have Gary one more time tell you his phone number. Reach out to him. He can definitely help you. I highly recommend him if you are thinking about putting together your will. It is a must-do. It doesn't matter. If you have any sort of money, children, you need to get on this ASAP. So again, give us your number, and thanks for listening.
It's 954-796-9600, and I am in my office most days, and Laura knows I return my phone calls usually within an hour. I know attorneys get a bad rap for not returning their calls for days, but not this lawyer.
Yeah. Well, thank you for coming here tonight, and thank you for
me.
watching us and listening to us. If you are looking for an attorney to do your will, give us a call. Laura Sanders.
Thank you for tuning in for Making Money with Laura Sanders, a name you can trust. To join the conversation, call us at the studio, 888-994-4995 Studio A, or contact Laura directly at 954-650-0827. Laura Sanders, a name you can trust.